Yes.
The second appeal of 2021, there is a current finding of both of those derogatory after. A judgment has been passed for recovery of position. Now the executing court is proceeding. Rate of delivery of position has been issued. Next date before the executing court is pending.
Give us it. Thursday. There is no defect. There is no defect. There is no defect. Or the appeal is defective.
I verify.
Verify it. Otherwise, if no defect, under order 41 rule 11. US
And one more case,
one only.
it is for ignorance of because
Mention to one. Yes.
The AMI dismissed for default on 28/2/20. CFT has been high court resolution.
This is supplementary on the second appeal 19 of 21 and the order dated 25/11/21 was called when it was directed to file supplementary affidavits for removal of impact. So we have done that and in lower courts execution proceeding has been initiated against the appellant. So I am praying for urgent listing of the case.
US
Millot 1 MF 418 of 2019. After further stamp reporting, some more defects were pointed out. We have removed other defects.
This is MA for under the Motor Vehicle Act or under the Succession Act?
In the Succession Act. So, to ignore the defects, we have.
It will be listed. It will be listed. Don't worry, it will be listed. The defects cases are being listed. There is a general instruction given to the office. Yes.
Some date for listing of second appeal 2017. And we are in appellate against concurrent findings of this body.
Yes. What is the urgency?
My long-standing position is under threat of
Any execution case filed?
my last. Yes, my last. Execution case certified. We are claiming the title on basis of this registered CLD and we will clear of the threat of downstream because of the ex-party judgment passed in another title of which we will not party.
US.
From supplementary causes under the heading for orders, serial number 1, MN number 344 of 16, Mr. Saurabh Shekhar.
Approval has been granted date in the within 1 minute.
Referring this to Lok Adalat? Yes. In the Lok Adalat, you settle that, you admit that you will pay the amount?
I'll pay the amount. Only question we are only one of the submission where we got an assurance.
Yes.
That we reserve our right to move departmentally against the driver because it was his responsibility to see that we.
No.
Only my submission that we.
No. That cannot be.
The departmental official negligence it is a misconduct because he was the custodian of the vehicle and he was responsible for keeping the fitness and all other documents updated. He never reported that it has expired.
That even if it is not there, who stops you? Who stops you from proceeding? No. You can make any sort of submission, it's open to you, but it has got nothing to do with this case. It's absolutely not related.
curiosity, one small recommendation.
Yes.
In the order passed by the Criminal and Motor Act, there is a on page 70, third paragraph. The joint liability has been created on part of the CCL and the driver. So I want to submit that part should be struck out from the.
They are paying it.
But actually, we are president for the other cases also. The driver should be liable for the.
Don't care for the world. Just save yourself. Take up. Mr. Amit Das, on instruction from his client, submits that the owner of the vehicle, that is Central Coalfields Limited, has taken a decision to satisfy the award.
Without prejudice. Without prejudice.
What prejudice? What prejudice? Tell me, let us understand. Unnecessarily putting some words which has got no relevance.
We have a reserve or right to proceed against any persons who are responsible. We are a company. If somebody has caused any negligence, because we got the vehicle insured.
That is always with you. Satisfying the award doesn't mean that you are precluded from proceeding against the departmentally against any other person.
Has taken a decision to satisfy the
Let's satisfy the award. Full stop. Next paragraph. This appeal has been filed by the driver of the vehicle, as the award is also against the driver. Full stop. Next paragraph. Since the owner has taken a decision to pay the amount of compensation to the claimants, this matter can be referred to the Lok Adalat. Full stop. This matter is referred to the Lok Adalat.
Serial number 2, second appeal 255 of 19, Mr. Sandeep Verma, Ms. Ritu Kumar, for the appellant.
The appeal filed on 21/97. The case of the appellant is very short enough that on authorization of the landlord, he entered with an agreement with the tenant with respect to which there is already.
What is the point of law formulated? This is an admitted appeal. Read that.
Order District 19/11/2019. The second.
This is for final hearing.
Yes.
This is for final hearing. Yes.
My lord, this second appeal has been admitted, my lord, by order dated 19/11/2019 by the Honorable Court, and the substantial question has been framed. Whether the learned court of appeal below has misconstrued the provision contained in order 21/97 and 99 of the Code of Civil Procedure, inasmuch as order 21/97 clearly states that any person, even including the judgment debtor, irrespective to the fact whether he claims derivative title from the judgment debtor or set up his own right or interest, divorce the judgment debtor, and he resists execution of decree, then the court, in addition to the power under order 35/3, has been empowered to conduct an inquiry as to whether the obstruction by that person in obtaining possession of immovable property was legal or not, and the finding of the learned court of appeal below, otherwise in this regard is fully perverse, same is again the mandate.
So what does the CPC come to this provision of the CPC Patravali?
the limitations be applied?
No, the question is this point of law has been formulated. Now, what is this point of law? It says that the procedure under Order 21, Rule 97, 99 has been overlooked. So let us see the procedure. Yesterday you had given it to me. See there? Where is it gone? It was there.
I'll have to check that out.
Huh?
I'll have to see that.
Let's come to Order 41, Rule 97. Order 21.
Well, Order 21 to 96. Resistance or obstruction.
Yes.
Rule 97. Resistance or obstruction to possession of immovable property. Where the holder of a decree for the possession of immovable property or the purchaser of any such property who sold in execution of a decree is resisted or by obstructed by any person in obtaining possession of the property, he may make an application to the court complaining of such resistance or obstruction. Where any application is made under subgroup 1, the court shall proceed to adjudicate upon the application in accordance with the provision here implemented. Thereafter, my lord, Rule 99. Disposition by decree holder or purchaser. Where any person other than the judgment debtor is dispossessed of immovable property by the holder of a decree for the possession of such property, where or where such property has been sold in execution of a decree by the purchaser thereof.
So this part is not applicable in your case. Purchaser of a property is not applicable.
That is not.
Yes.
Or where such property by the he may make an application to the court complaining of such disposition. Now, since there was a application was filed in view of the fact that
Then, okay. So, this too provides that if a person who is not a party to the suit is sought to be dispossessed by virtue of a decree, he can complain before the appropriate court against such disposition. So, these two provisions give a person a right to make a complaint who is not a party to the suit and who is being sought to be dispossessed. Now, question is, you may make a complaint. What sort of complaint it should be, and what should be there in the complaint so that the court can pass an order in your favor? What will be the nature? Because just stating that I am being dispossessed, that is not enough. Now, let us come to the facts of this case. What is the facts? What was the suit for?
Suit was initially suit was filed, my lord. Eviction suit was filed.
Let us see the LCR of the title suit, eviction suit. Let us come to the plaints.
My lord, eviction suit 3 of 2010. My lord, I am referring to the judgment.
No, let's come to the plaints. Let us see the plaints.
The page of mine, sorry, my lord.
Plaint. Come to the plaint.
My lord, page number, my lord.
Do you have
Page number 17 of my memo. So that I am not referring for the LCR.
Let us go through the. You have the plaint with you.
Yes, yes.
Read the plaint. The residential flat number so and so situated on the third floor. Madhusudan apartment, Deepra Road, Mango, Jamshedpur, Schedule defendant Shubhanshu Shekhar Giri was used in accommodation since December 10 by the plaintiff number 1.
My lord, 11/9/2018, the first paragraph of the plaint, whether execution case, in the execution case application was filed under order 21, my lord.
No, the plaint of the eviction suit.
I don't have the plaint, my lord.
You have the plaint? Admittedly, you were not a party to the suit.
No, admitted. My lord, the plaint is, my lord, residential flat number 305 situated at third floor of the multi-story building known as Madhusudan Apartment, Digna Road, Mango, within PS Mango, PO Mango, Town Jamshedpur, District East Singhbhum, fully described in Schedule A below, also situated within the jurisdiction of this court, is the subject matter of this suit, and hereinafter called the suit premises or suit flat. The said flat number 305 is under the ownership of the plaintiff number 2, Srimati Kumar Bose. That the defendant Sudhanshu Shekhar Giri was allowed to use and occupy the Schedule A suit flat since 10th day of December 2007 by the plaintiff number 1 as a monthly tenant of plaintiffs on rent payable at the rate of ₹3,500 per month. Electricity charges and monthly maintenance costs for the suit flat are payable by the defendant separately. The tenancy month thus commence from the 10th day of each English calendar month, ending with the expiry of the 9th day of the next following English calendar month. The suit premises was let out to the defendant by written tenancy agreement dated such and such, executed by the plaintiff and the defendant for a fixed period of 11 months, which is has been expired on 9/11/2008. That the defendant, in the beginning of the commencement of the tenancy, paid monthly rent payable by him for the suit flat only for 6 months, amounting to ₹21,000.
So rest are immaterial because
Yes,
you are not a party. I just wanted to see that who was the tenant.
Sudhanshu Shekhar Giri.
Now let us come to the written statement. What is his averment?
The written statement filed by the tenant.
Yes.
In paragraph 6, they have taken one ground, plaintiff have taken ₹21,000, but that is not the relevant case now. And there is no reference also, my lord, from the that B1 equalization or.
I want to see that only.
Yes.
In the plaint, he has not denied that he is not a tenant.
Yes. Para 10 is admitted, my lord. When defendant approached them to pay the rent, this is the admission of his Sudhanshu Shekhar Giri. In this statement, para 10.
Para 9 also.
Yes, that is also.
And there is nothing to state that he has given possession.
Yes, but because this written statement has been filed, my lord, filed on 14/8/2011.
14/10/2011.
2011. And thereafter issues have been framed.
So now thereafter, both the courts granted a degree of eviction.
Well, that is it.
Now this part is over. Now let us come to your.
One more thing. Now, the only material thing is now my application.
Your application
Yes.
under order 21.
20.
Where is it?
And the para one is very important.
Let me see, where is it?
I break up in the email.
No, I have called the load code record, it must be here. It is miss case number?
Miss case number, my lord, execution case 1 of 2018 made was filed, my lord. It would be in the execution case record, my lord.
Execution case record.
And subsequently, this case number has been registered, my lord, 43 of 2018.
43 is the miss case.
2018
18 or 19?
18 43 of 2018 civil miscellaneous case 43 of 2018.
It says 19. Miss appeal 11 of 19.
So that is the order of the first appeal. In this way, the judgment was appellate court.
Where is the miss case number? Miss case
43 by 18.
43 18. Where is the record? Miss case 43 of 18 record.
Case of the applicant in under order 21 to 97 is very small matter fact matter that on
Just let me find it out.
Sorry.
Hard copy can. Hard copy is here. Yes, yes. It has been sent through special messenger. Till office. Yes. Yes. 43 of 80.
Mother, execution case application mother.
Yes. I got it.
The very first plan. Correct.
Is the respondent in the year 2014.
Yes. That the equal whether I am reading the original application filed by the applicant.
Yes, yes, yes. The respondent in the year 2014. This is the first paragraph.
No, So this is the application filed in the executive court in execution case 180, petition under order 21 June 97 June 101.
Read with section 151.
Yes, sir.
The applicant above named most respectfully states as follows: that the respondents in the year 2014.
Pilot.
Yes.
That the degree holder in the year 2014
Where? This is the no. You are reading which paragraph?
Reading the first paragraph, certified copy mirror, photocopy of the certified copy mirror.
No, that the respondent in the year 2014 approached the applicants. Do you have a copy of it?
This is dated mirror 11/9/2018.
22/6/2018. Signed by advocate. Original. Do you have it?
No, I don't have it. But the case of the applicant is also reflected in the.
No. I want to see what statement they have made. Yes.
Now, the only relevant fact I want to draw my lord's attention.
No. First, let us be on the same page. Because this.
केवल डिग्री होल्डर का petition different date का भी लगा है। मेरे पास तो 11/9/2018 का petition।
No. This is 22/6/2018 which was filed.
Section of the is saying that the original is not missing or the photocopy is missing.
It was the order. Order क्या था?
May I submit one?
So, the necessity for sending a special messenger for sending a photocopies. this letter? What does this letter mean? Who has written over in the pencil? It has been written most probably from here. You read the letter, original letter. Now see one thing.
Only one thing I want to indicate, my very much. Order sheet of execution case also reflect that on 11/9/2018, application I have annexed this order sheet.
So that you have filed in the execution case.
Yes.
The special miss case has.
No, thereafter the same was the same could have been registered. जो जो पहले execution में file होगा, I will file and thereafter it will be registered.
See the order sheet, 22/6/2018. The first order sheet of miscase 43 of 18 is 22/6/2018. A petition has been filed under Order 21 Rule 97 101 read with Section 151.
Sorry, I was referring from the execution case order sheet.
No, it starts from 22/6. Yes.
Section of business is saying that he has written the letter for his own case paper, not hard copy of stamp copy. But they have sent it stamp copy. So direction, earlier direction of Mr. Honorable Chief Justice that only stamp copy has to be sent to the court. Until unless otherwise.
That is there. You understand?
Yes, I understood.
So it matches with the order sheet, this document.
Yes.
Now you see that document I am reading for you. It is not with you. In paragraph 7, you have stated that thereafter on receipt of the amount, the tenant on 4/7/14, mark the date.
Yes.
4/7/14 handed over vacant possession. Now, if the tenant had handed over vacant possession, this written statement in the suit was filed much later.
Even evidence was of the event was in the year 2016.
2016. Then what does?
Only one limited submission. Only limited. Both the courts below have read that I am claiming through delay. But even the application from era 1, which will reveal that there was an agreement, not in terms, there was an authorization by the original landlord, and that these two premises should be vacated, then the same should be sold to you.
So that is absolutely a different cause of action. It was not sold to you.
Later in the next manner in that is manner.
Yes. You are trying to get some benefit out of the said letter.
Yes.
As a proposed purchaser.
Yes.
So now, can that be seen in an eviction suit? Can that be a scope of Order 21 Rule 97 in an eviction suit? What about the BBC?
There is Section 12.
Section 12?
I know of that. There is Section 12.
Now, if you have got any claim, it's a separate claim, independent of the title suit, you can sue the landlord. Or for the breach of contract, or you may say for specific performance or anything, but not in an eviction suit. So the question of law which has been formulated, that let me again understand this, whether the learned court of appeal below has misconstrued the provision contained in order 21 Rule 97 and 99 of the Code of Civil Matches. The order 21 Rule 99 clearly speaks that any person, even including the judgment debtor. Yes, what is wrong? Court has given you a hearing. They have given you your opportunity. You had given the opportunity to file an application under Order 21 Rule 97 99. That was adjudicated.
The money receipt has been considered by both.
It has been adjudicated. Even if it was not considered, then also.
Yes.
You are not claiming title independently. You are not claiming title admittedly over the property. When you are not claiming a title, then you are claiming what? You are claiming possession only. Now, even if you are in possession, then it has to be seen your possession. What is the nature of your possession?
So firstly, this applicant tried to set out a case or not that he is in possession upon the authorization of the landlord.
Landlord after a mutual understanding with the tenant and he vacated. But this fact which you are trying to canvass before the first court, second court and before this court also is not supported by say cogent evidence, because it could have been if the plaintiff, if the defendant in the suit, that is the landlord, he would have vacated the suit, then the natural conduct would be he would come and say that this suit is not against because I have already vacated, this suit fails.
But that's why initially I submitted matter, but I only limited scope to argue this case. That there is a finding of the court that there is no any document or sheet of paper how the tenant received the aforesaid amount and handed over to the applicant. Now both the courts only limited submission matter to that effect and failed to consider that one document was produced by the applicant in order to show that he is not claiming directly through the judgment debtor, rather the
degree holder, he is claiming through
Yes.
the degree holder, but
Yes.
but it hardly matters
Yes.
in this
So-
eviction
so
suit.
this
It
is
has
what-
got no relevance. It has got no relevance.
and that document has not been even looked into by any of them.
Even if it was looked into, then also would it confer any right upon you in an eviction suit?
Title will not be conferred.
Title will not be conferred.
So my only submission was that both the courts have considered the scope of section 12 of BPC Act.
So both the courts have considered the scope of section 12. Both the courts have, in the Miss case and Miss appeal,
Yes.
have considered the scope of order 21 to 97 also.
That is their matter, but that was only limited point that document none of the courts have. That's why I was asking matter that whether this document is on the record, then it
So
can only be
the
used.
court says by non-consideration of this this order 21 to 97, this judgment in the Miss case and the Miss appeal is perverse. What is the perversity?
That is
If in the alternative, if that would have been considered and a judgment would have come, then that would have been a perversity.
correct.
Is it not? So then,
Only that part.
you have independent title. If you want to assert your independent title, not in this suit.
We should file separately.
Yes.
Coming to order 21, rule 102.
Order 21 rule 102.
Yes. Order 21 rule 102. Rules not applicable to transferring tenant right. Nothing in rules 98 and 100 shall apply to resistance or obstruction in execution of a decree for the possession of immovable property by a person to whom the judgment debtor has transferred the property.
That's why I have made argument that I am provision.
This is one aspect. The other aspect is
Section 12.
Section 12 date is 102.
this is yes 102. And the other aspect of this matter is the applicant had knowledge about pendency of the eviction. That can be reflected from page 15 of the memo.
Page
Page 15.
15.
Yes, that is the order of the first appellate court. I will just read out the two lines.
Where is it? Judgment. You are referring to the judgment.
Yes. Internal page.
Judgment of
First appellate.
in Miss appeal.
Yes, disappeal. It says that eviction suit proceeded from 2010 to 2017 and Sudhanshu Shekhar Giri, the tenant, had initially appeared and was contesting the suit, but subsequently stopped taking steps and later on again appeared by filing fresh Wakalatnama, and several witnesses were examined on behalf of Sudhanshu Shekhar Giri. But each of the witnesses in their statement has stated that they were asked to depose that witness by the present appellant Sudhir Kumar Pathak. Thus, eviction suit was being prosecuted.
Where is it? Where is it? Let's see the evidence.
This is the evidence.
Evidence in the title suits or the execution suits. Eviction. Oh, sorry, eviction suits.
I knew your document.
He had, that is my submission. this applicant had knowledge about pendency of the eviction suit, and he chose not to appear in that eviction suit and instead chose to appear at the time of delivery of possession, writ for delivery of possession.
No, that is in relation to the conduct taken by the Sudhanshu secretary.
Yes, okay.
So I have limited ground that I have taken a minor
Judgment reserved.
my deeply original.
One judgment I want
Yes.
to cite.
Any judgment you want to cite?
Yes.
Yes.
I read out a few lines from the judgment.
Yes.
At there be no adjudication, there were several judgments given since the matter has been adjudicated.
I'm reading on para 17.
Para 17.
Para 17. After Rule 102 was quoted, after that it says,
Yes.
their reading of the rule makes it clear that it is based on justice, equity, and good conscience. A transferee from a judgment debtor is presumed to be aware of the proceedings before a court of law. He should be careful before he purchases the property which is the subject matter of litigation. It recognizes the doctrine of independence recognized by Section 62 of GDR. Rule 102 of Order 21 of the Court thus takes into account the ground reality and refuses to extend helping hand to purchasers of property in respect of which litigation is pending. If unfair, inequitable, or undeserved protection is afforded to a transferee pending, a decree holder will never be able to realize the fruits of his decree. Every time the decree holder seeks a direction from a court to execute the decree, the judgment debtor or his transferee will transfer the property, and the new transferee will offer resistance or cause obstruction to avoid such a situation. The rule has to be enacted. Then your Lordship, para 23. It is thus settled law that the purchaser of a suit property during the pendency of litigation has no right to resist or obstruct execution of decree passed by a competent court. The doctrine of risk prohibits a party from dealing with the property, which is the subject matter of the suit. This itself is treated as constructive notice to a purchaser that he is bound by a decree to be entered in the pending suit. Rule 102 therefore clarifies that there should not be resistance or obstruction by a transferring pendant.
24. Read para 24.
Yes, this is the judgment.
Read it.
In Silverlight Forum, Private Limited versus Rajiv Trust, this court held that where the resistance is caused or obstruction is offered by a transferring pendant, the scope of adjudication is confined to a question whether he was a transferee during the pendency of a suit in which the decree was passed. Once the finding is in the affirmative, the executing court must hold that he had no right to resist or obstruct, and such person cannot seek protection.
So it's finished. See, if the court finds that your obstruction or your possession, even if your possession, at the behest of the landlord also, so during pendency of the suit, then in view of Silverline Forum, you cannot.
Silverline की judgment might not be fact. The facts of this case was not that there was any authorization from the.
No, even if there is authorization.
Even
if there is authorization.
And every case of the Order 21/19, had it been the case that I am claiming to the judgment debtor, I would have no case. But since the case is at hand manner entirely different, and both the courts have been different, both have started to adjudicate this point that I am claiming to the
So I'm putting a question to you. You say that the landlord has given you possession by virtue of some letter or agreement, something like that.
Yes, on authorization. Yes.
Yes. Now, as per you, when did this happen? During pendency of the suit? At the pendency of the suit? Did you intervene in the suit and file any application? Then
That's why.
who prevented you? If that would have been there, then something would have come in the proceedings to suggest. Judgment reserved.
Deeply operational.
give your appearance slips. List. Okay. Lily. Yes. Records. Yes, yes. Yes.
From very list under the heading orders with defect, serial number 1, second appeal 217 of 80.
Remove the defects. 3 weeks to remove the defects.
Serial number 2, second appeal 223 of 80. Mr. Kaushik Sarkar.
3 weeks. 3 weeks to remove the defects.
Serial number 3, second appeal 226 of 80. Mr. Rohit Roy.
3 weeks. Defect number 2. Let the certified copy of the judgment and decree under appeal be sent to the court below for making necessary corrections in view of the office note dated 5/4/2021. The defects, the defects should be removed. Once the certified copy, corrected certified copy is received by the office, the counsel for the applicant should be notified by the office. Full stop. The defect should be removed within 3 weeks thereafter.
Serial number 4, second appeal 234 of 18. Mr. Manoj Kumar Chaube for the appellant.
3 weeks. No, लिखे. Just आगे वाला जो लिखे है ना, this not this one, the earlier one. 3 weeks. 3 weeks time. 21 days. 21 working days is granted to remove the defect. Same. 21 working days is granted to remove the defects. 21 days.
Serial number 5, second appeal 242 of 18. Mr. Amar Kumar Sinha for the appellant.
21 working days granted to remove the defects.
Serial number 6, second appeal 259 of 18.
21 working days to remove the defects.
Serial number 7, second appeal 265 of 18. Mr. Jitendra Kumar Kasari for appellant.
No one appears, however, 21 days, 21 working days are granted to remove the defect.
Serial number 8, second appeal 293 of 18. Mr. Rohit Roy for appellant.
Same order.
Serial number 9, second appeal 298 of 18. Mr.
Same order.
Serial number 10, second appeal 390 of 18. Mr. P.K. Verma for the appellant.
No one appears, however, 21 days, 21 working days granted to remove the defect.
Under the heading for orders, serial number 11, second appeal 493 of 15. Mr. Sudhanshu Shekhar Chaudhary for the appellant.
As for the office note, come on, the respondent number 6 has died long back. First up. Respondent number 6 was neither substituted. The respondent number 6 was neither substituted in the appeal nor at this stage. Not at the first appeal nor at this stage. First up. This appeal, so far as respondent number 6 is concerned, stands awaited. Is this case under the heading for it? Order 41 Rule 11 in usual course.
Serial number 12, second appeal 552 of 15, Ms. Mohawali for appellant.
Seven days time granted. 7 working days time granted to comply the earlier order. To file requisites.
Serial number 13, second appeal 109 of 16, Mr. Rohit Roy.
There are only 3 respondents. Notice which was served upon respondent number 2 and 3 is treated to be a valid service. It's treated to be validly served. Stop. It has been reported that respondent number 1 is dead. Stop. The counsel for the appellant prays for some time to adjourn this case. Prays to adjourn this case for taking appropriate steps. They are allowed this case is adjourned.
Serial number 14, second appeal 139 of 16, Mr. Bhaiya Vishwajit Kumar for appellant.
Copy of judgment of parties is not qualified.
14 days, 14 working days to remove the defects, to file the typed copy.
Serial number 15, second appeal 180 of 16, Mr. Jitesh Kumar.
Possession has been given by the executive court. So far the possession concern my suggestion is that there is provision of section 144 of CPC. So this appeal may not be available by this court.
What was the suit for?
Suit for declaration of right title interest in the possession of possession.
The counsel, yes, will hear the main appeal, will hear the appeal on merits. So that doesn't mean that his right has been extinguished. If it is found that he is entitled to get some relief, he will, the position will be restored.
Yes.
So we'll hear it on merit. This is for under the heading for orders. Why it has come for orders?
There is no petition below on that part also. But on order dated 1/4/2019, order number 6 below.
Yes.
It has been mentioned that the IA number 9188 of 2020 shall be heard at the time of petition.
What is this 9188?
For amendment of petition below, as it was in house title, one dead person has signed without wakalatnama. One dead person. That's because there are so many persons, or many persons put their thumb impression. So advocate clerk could not identify them properly. So it was mistake committed. So amendment petition has been filed, stating therein that due to inappropriately by mistake.
On the request of the parties, unless this case in usual course for hearing under Order 41 Rule 11.
Serial number 16, second appeal 512 of 16. Mr. Arvind Kumar Sinha, Mr. Jitesh Kumar.
Lord, on your opinion, this is verified to respond number 128. Service report has come, and from service report, we came to know that respond number 6, 7, and 8 are granted. So, to which
Counsel for the applicant submits that they have come to know from the service report of notice that respondent number 6, 7, and 8 is dead. Full stop. He prays to adjourn this case for taking appropriate steps. This case is adjourned. Give your script.
Serial number 17, second appeal 519 of 16. Mr. Pramod Kumar Sinha, Mr. Praveen Akholi for the appellant.
Pass over.
Serial number 18, second appeal 528 of 16.
Substitution application has been filed for substitution of legal heirs of reporting number 1 during the pendency of the
This is 528.
This is 528 IE number 2005
111.
54.
What is the date of death?
Well, the date of death is 20/12/2017, para 1 notice
And you have filed this on?
on ballot. Page 11 application and ballot so composite ballot.
IA number 1154 of 2019. By filing this application, the petitioner has prayed to substitute the deceased respondent number 1, who died on 20/12/2017. A prayer has also been made to condone the delay in filing the substitution application and also set aside the abatement. Next one. Counsel for the appellant submits that the respondent number 1 died on 20/12/2017, leaving behind 3 legal heirs, namely so and so. He submits that cause of action survives and devolves upon the legal heirs, thus they need to be substituted. Next one. It is further mentioned that the deponent Anand Kumar Pandey fell ill in the first week of October 2019 and he was advised bed rest. Full stop. After recovering, he came to Ranchi on 1/12/2019 and instructed his counsel to file a substitution petition. He further submits that the substitution petition couldn't be filed within time because of the illness. Due to the illness of the said appellant, he prays that the delay may be condoned and abatement, if any, be set aside. Hearing the after hearing the counsel for the appellant, I find that good ground has been shown to condone the delay in filing the substitution application. The delay is condoned. Further, since the cause of action survives, it is necessary to substitute the deceased respondent number 1. by his legal heir, namely 1, 2, 3, 4, 1, 2, 3. Full stop. The amendment, if any, is also set aside. This IA stands allowed. Notices were issued earlier? No. It has not come. It has not come for hearing. Wait.
Serial number 90, second copy 530 of 60, Mr. Arvind Kumar Sinha, Mr. Jitesh Kumar.
We have filed IA number 5620 of 2019 for substitution of AS and individual for cabinet number 2, namely Badam Mato.
When did he die?
Yes, sir.
Okay. We give the appellant number 2, namely appellant number 2. Appellant number 2, Badan Mato is he is the appellant. So one is deleted. Click at the appellant Badan Mato is dead. So this application has been filed to substitute the late the appellant Badan Mahato, who died on 1st April 2019 by his legal heir, namely Suresh Mahato, Yudhishthir, Jitan, so and so. Paragraph 2. Paragraph 2.
Paragraph 3, we have written 4 sons are already partying, only 2 daughters are
It is submitted next one. It is submitted that Suresh Mahato, Yudhishthir Mahato, Jitan Mahato are already a party as the appellants.
Yes.
Only the daughters, namely Chapala Mahatain and Kuta Mahatain, are required to be substituted.
Yes.
Full stop. It submits that the cause of action survives. And this substitution petition is well within time. Where have you stated that the cause of action survives? Where have you stated that the cause of action survives? If there is no cause of action to substitute, why should I substitute? What is the suit for?
Suit is for
partition suit.
Yes.
Partition suit. Full stop. Next paragraph. Considering the fact that the suit was for partition and the cause of action survives, Chapala Mahatwain and Kuta Mahatain be substituted in place of the deceased so and so. Rest of this idea stands allowed.
Serial number 20, second copy 536 of 60, Ms. Mahua Pali.
Who is dead?
They are going to respond and so on. They are not appeared up till now, but I have not this one number 4 has died.
This one number 4 has died. Take the necessary corrections to be made in the cause cited by the council for the applicant within 3 weeks. Normal substitution petition. You don't know the exact date of death?
No. The respondent probably they have not appeared. They would have said that.
Take down. This application has been filed for substituting the deceased respondent number 4, Gopal Orao alias Gopal Kirkitta, who died sometime in the month of August 2019. Next paragraph. Senior counsel appearing on behalf of the appellant submits that the exact date of death is not known, as the appellant was residing in Bihar, in the state of Bihar, and was working as a laborer. Full stop. It is submitted that when he who was working in Bihar? So he submits that he could come to know sometime in January 2020 that the respondent number 4 died. So he immediately rushed to Hazaribagh to obtain the death certificate, to obtain the necessary papers, and thereafter he contacted his counsel in March 2020 when this application for substitution is filed. He submits that the cause of action survives, thus the legal heirs of deceased respondent number 4 is a necessary party to this appeal. He submits that the deceased has left behind the following legal heirs, para 4, who needs to be substituted. Next one. Considering the submission, he also praised that on the grounds stated above, the delay in filing the substitution petition be condoned and the abatement, if any, be set aside. Next one. Considering the submission of the learned counsel for the senior counsel for the appellants, and since the cause of action survives, it is necessary to substitute the deceased respondent number 4, Gopal Orao alias Gopal Kirkitta, by his legal heirs, namely so and so. Full stop. The delay in filing this application is condoned as sufficient ground has been shown to condone the same. Full stop. Abatement, if any, is set aside. Full stop. Necessary corrections to be carried out within 3 weeks. This I stands.
Serial number 21, second appeal 558 of 60, Mr. Patel Neeraj Rai.
Wait, by order dated 20th of January 2020, Lord has noted that the learned counsel for the other side, Mr. Ramodar Sharma, Lord had informed that 2 people have died. Lord, my client is not an old man, he is not able to ascertain. Lord, we have been able to gather the name and village. Lord, if the requested my friend also, Lord, it would be possible for him to disclose.
Where is he?
Not clear.
On the request of the counsel, no one appears on behalf of the respondent. This case is adjourned for 4 weeks.
We have been able to gather names and name of the village. We are very brave.
Yes.
You also would allow your notice to be served to the police station. Then we can in a statement.
Let him appear, he is not appearing also. Yes.
Serial number 22, second appeal 301 of 18, Mr. Vinay Kumar Sahai.
Who died? Respondent number 5. Just a minute. The respondent number 5 has died on 8/4/2021. leaving behind his widow Basanti Devi and son Rahul Singh and daughter Babli Devi.
And it was not quite clear the person because there was less participation and it quite on 18
Died on 8/4/21. So there will be no delay in view of the order passed by the Honorable Supreme Court.
Yes.
The limitation has been extended. Next paragraph, the counsel for the appellant submits that the cause of action survives, and thus the deceased respondent number 2 be substituted by his widow, son and daughter, namely so and so. He further submits that the date of death is 8/4/2021, but in view of the order of the Honorable Supreme Court, the limitation has been extended. It cannot be said that it cannot be construed that the application was filed at a belated stage, which was in fact filed on 18/10/2020. Next paragraph. Considering the submission, I find that sufficient ground has. I find that the cause of action survives. Thus, respondent number 2 needs to be substituted. Let the name of respondent number 2 be deleted, and in his place, the name of so and so be incorporated. This I allow necessary corrections in writing within 3 weeks.
Both are here.
Both. What is the thing?
One for substitution, one for limitation.
Limitation, I both together.
Serial number 23, second appeal, 50 of 90, Mr. Amresh Kumar, Mr. Indrajit Sinha.
What is this? This is an admitted appeal.
No, there was only one thing, only to shorten the matter, rent control matter, and there are 3 appeals. One is for bringing safety. This relates to default and personal necessity on those 2 grounds. The appellate court and the trial court have agreed. Now they are challenging in the Chennai matter. Now pursuant to the order passed by the appellate court, the B, that is the respondent original plaintiff, they transferred the property in favor of the interveners. Now, therefore, the cause of action as regards personal necessity did not survive. That for that they have brought the safety under order 41/27. That can be allowed.
No, I am not understanding what it is. The suit was for eviction. Between
the appellant and the respondent here.
you are the appellant.
Yes, I am.
You are the landlord.
I am the land. Original plaintiff.
Okay. So, what is the finding of the trial court? I'm asking a question. You should know something. You are the The eviction suit was filed by you.
Yes.
You are the landlord.
I am the.
Then it was decreed by both the court.
Yes.
The decreed by the trial court and then dismissed by the their appeal is dismissed by the. Then what happened?
Then subsequent to the disposal of the first appeal, we have transferred the property to the interveners. Now therefore they had brought on board a sale deed which was executed by the original plaintiff.
Just to show that the personal necessity is not
only
there.
yes, only to. But as regards default, that it still stands.
What is the personal necessity? What is the definition and to what extent? What is the personal necessity? How do you define personal necessity? under the BBC Act.
Requirement of the landlord to
Read that, read that. Suppose a landlord has a huge dues, or his daughter is going to marry, he has got no other premises. He wants to sell the premises. And the purchaser says that I don't want to purchase a property with a tenant. He files an eviction suit and sells the property later on to get the money to marry his daughter and for other purpose. Can't it be said to be a personal? Yes.
What was the and for what purpose they require?
Is it necessary to give the purpose?
Plus, the personal necessity has to be clear.
Yes, it has to be pleaded and proved that I have some necessity. That I have necessity.
Yes. For what reason that necessity is there? But I have to find responsible to have to put this because my understanding is that
What about default? What about default? How do you escape default?
I have to say in terms of order 21 rule 16, it's a post-degree situation. Unless there is a written assignment, new landlord cannot say a new person who is
No, he is the new landlord.
yes, who he has filed his IA.
For not on the IA, I am saying the suit.
In suit matter, so far as default is concerned, Transport has never said that there is a default. Rather, the appellate court has relied on a certain thing which was beyond the scope of the pleading and defense and has said, therefore, you have committed default. My specific case is in play. There is no month shown from which I have defaulted. And this is my basic case, that there is a statutory form prescribed in PVC also. This act itself in appendix. And the appendix shows that there has to be a specific.
What is their pleading? What is their pleading on default?
On default?
Yes.
I will read one of we have filed a conviction compilation of the convenient compilation, copy of print, and the resolution. In July, they said on because they have filed intervention by the and your lordship had directed them to file because your lordship was of the view, not directly, your lordship was of the view that the subsequent transferee, since he would be bound by the ultimate result of the suit, therefore he must be drawn. And therefore he has filed. The original transferee, she had filed an application for intervention. After filing of the intervention, she died. So that is one of the IA. And subsequently, another IA has been filed by her legal. So one IA I am not pressing, he is not pressing the 477 because after filing of the intervention, she died. And therefore, another IA was filed by.
No, just tell me one thing. What is the scope of this impleadment? This is an eviction suit. What is the right of a subsequent purchaser in the eviction suit?
But as per Supreme Court, there is only two parties required.
Tell me.
In eviction suit.
What locus does they have now in eviction suit?
That they would be bound by the ultimate result of.
So is it necessary to implead them as a party?
No.
Then
even otherwise.
What the law says? See, convenience and all these things cannot override the law. What does the law say?
Law says that if an application is filed by a subsequent transfer, he must be there.
Where is that? Show. So you will say that now you will not contest.
No, I am contesting. But he has
Subsequent transfer will abide by.
You have to abide by the finding.
He would be bound by the. Your Lordship may kindly see order 22.
So he will be impleaded only for the purpose of assisting you in the argument, not for any other purpose.
And even otherwise he would be bound by since he would be bound
Yes.
by the result of.
So is it necessary to implead him as a party? Tell me.
It is not, but there are that. There are that means in view of order 22 rule 10, your Lordship may kindly see order 22.
Yes.
That is my
Yes.
objection to because order 22 rule 10 or after order 21/16, both says assignment, and that is assignment before final order in the suit. Mothers may have placed two provisions. Mothers may kindly come to order.
Oh, you are saying order 2021 rule?
Order 21 and 22C.
Order 21 rule 16.
Yes, it deals with both positions.
Yes.
That is pre-decree and post-decree. And that is with respect of money. Kindly come to order 21 to 16. Where
Yes.
a decree or if a decree has been passed jointly in favor of two or more persons, the interest of the holder in the decree is transferred by assignment in writing or by operation of law. Now I have to say where in the said date it has been assigned. And there cannot be in the operation of law that his state, because whatever my authority, suppose state rupees is due to him, that has become his state. Whether he has transferred that 10 rupees to the new purchaser, that monetary part is concerned. And it deals with both pre-decree and post-decree situation. And there is judgment of Honorable Supreme Court that it deals with both money suits or part of monetary claim. This order 21/20 rule 16 does not distinguish between pre-decree and post-decree situation. And therefore my objection is that now the personal necessity does not survive. My submission, if the default is there and something is required to be paid from my end, then if the decree holder wants to transfer it, it has to be assigned by in writing or by operation of law. And operation of law will not be an automatic. He may transfer that property, but he will get arrears from me. That is his money. He is required to be transferred by way of writing. There is no express way of writing. Then my errors may come under 23. Who will take what they are saying. There was no 93 was happening. I agree on this one. It is Hukum Chand. It must be there on the record. Hukum Chand versus 2001 volume 10 SCC page 17. It was filed. 2001 volume 10 SCC page 17.
Where is it? Now, what is the issue? They have sold the land, they have sold the property, and you say that there is, so far as default is concerned, there is no finding against you.
Yes, by the track, and the appellate court has said the evidence is there, therefore I am holding you are a defaulter. And my case is, perhaps may already come to that convenient compilation. Page 3 of the claim. My weakness cannot become his strength. Paragraph 7. That the plaintiff in the year 2008 demanded enhanced rate from the defendants, but they flatly refused for any enhancement, and ultimately they have stopped making payment of any rate and have become defaulter in the eye of law. The question is, in the year 2008, which month? And the statutory form amended with this act says this month to this month. How can I take a defense when it is not known to me what is the charge against me? This is my first argument. What I have done is a material thing. They have to succeed on the basis of their own pleading. And surprisingly, no exact month is mentioned in any of the deposition of the PW cases. Somebody has tried to just fill up that lacuna, so that also we can argue. So let it come on inconvenient day, we have prepared.
Yes, because even appellate court has completely discussed all these issues, and it has come to specific finding that the money orders which he is relying, all those are false. He has not.
Money order what I have designed is marked without objection. How can a court of law, in a presumption, say it's a forged document? That is also one of the points. If the document
This has not been admitted.
No. It has to come under
List this case under order 41 after 2 weeks. The 41 rules when all the petitions, along with all the ideas.
But there is a victory order. That may continue.
Yes,
Even otherwise I'm not proceeding with the. If we are depositing rate, before the director deposit 30%.
What is your stand? You are still a tenant.
I'm still a tenant. I'm paying rent, whatever the court has paid by interim order, each month I have got the receipts and have the receipts also. Like each month, I have the property, there are two data.
You are not claiming title of the property.
Perhaps the question which requires certification by you, whether the title gives the right of eviction or a dual relationship of landlord and tenant gives right of eviction. The law is very certain that title doesn't give any right of eviction. And the subsequent purchaser, the recital of certificate is also important to this. But whether the automatic assignment.
Atonement is there, not there. Atonement is not there.
They say atonement is there for a period. I say I continue to pay it. You have brought suit for the reason to show that I am defaulter in 2008. But which one? If the fact is not ascertainable, how can I defend myself? And therefore the trial court rightly disbelieved and said that there is no finding with respect to it.
And what about the personal necessity?
But so personal necessity, right now I have to say that since the property is transferred, there are.
No. What was there in the pleadings?
With respect to personal
I must admit against me that you will the appellate court itself has not found the personal necessity. It has said therefore I am not challenging. My only case is on default. Only case is on default.
But default and personal necessity. Trial court says no default but personal necessity. One says no personal necessity but there is default.
One more thing that would go against me is that I have filed a suit for personal necessity. I have said that I require the property and then I have sold the property. So there are judgments which say that personal necessity would not serve. So I am not pressing on that. But the finding of the
No, there are judgments. Suppose you plead that I want X amount of money which can only be obtained after selling this property and a person is not purchasing.
That on the ground of personal necessity, they will recover position for this much period they cannot transfer it. So that means that I want to sell this, he has to wait for that step.
Yes, absolutely.
Yes. Therefore, whether that requirement has to be seen.
That pleading has to be there.
Yes.
So in the plaint, what is the pleading of personal necessity?
The trial court says there is personal necessity, but the appellate court says no personal necessity. They are not challenged it right now. No,
on what basis the trial court says that there is a personal necessity? What is the pleadings I am asking? What is the pleading?
It is in para 8, it says that only 2 lines, that since the suit property is situated on main road, the plaintiff also required the suit premises for his own personal necessity for carrying on his business and business of his son, so and so.
So once you sell it, that means this statement is not correct. So now the only point which remains is whether there is default or none, whether the pleadings of default. What about the default pleading?
Default pleading, paragraph 7 of the plate. No one is mentioned that the plaintiff in the year 2008 demanded enhanced rent. Two words are important. No one mentioned and not rent, enhanced rent. What is the enhanced rent? That is also has to be seen. From the defendants, but they flatly refused for any enhancement and ultimately they have stopped making payment of any rent and have become defaulted.
From when? From when they have stopped making any payment?
No such thing. No such. But your Lordship, this suit was filed in the year 2012, after 4 years. And therefore we say that since 2008 itself they have not paid. So whether I was, as a plaintiff, I was required to mention each and every month after 2012, when it was, the default went in years and not months. Only 2 months was required.
From which period to 2 months?
Even assuming that it was after 2008,
2009 they have to show that since 2009 they have to pay.
But then the default cannot be future default. There has to be bleeding. Right now I am paying you.
Suit was filed when?
Suit was filed in the year 2000.
2012.
Paragraph 10 that the plaintiff requested the defendants to vacate the suit premises on 2012. The plaintiff requires the suit premises for his own use and occupation.
That they have failed to prove.
And more so, since the condition of the suit premises has been deteriorated to such extent that it may fall at any moment, causing loss to life and property. But the defendant flatly refused.
That is also not a ground to eviction.
Yes, cause of action, as they rather paid the rent nor vacated the suit premises.
So their case is you have not paid the rent from sometime from 2008 onwards.
Yes.
2008 onwards.
2008, sometime.
So forget about the date, starting date. Is it your case? No, I have paid rent throughout from 2008 till filing of the suit.
Yes, I had shown for the 2008 period money receipts, postal money receipts. That was exhibited without any objection from their side. But the appellate court says it appears to be full. My objection would be at right now. When a document was marked exhibit without any objection, its admissibility was not challenged, its relevance was not challenged, then how come, without any contrary evidence, the appellate court can say it's a doubtful document?
Only one line, so I am not repeating it once again. The appellate court has noted that they have said that we refuse to accept rent, whereas the money order there is signature of the payee. So therefore, it cannot be signature of the payee. Their case is that I have refused to accept. So how can there be a signature of the payee?
I think there is a confusion. My learned friend and the judge at lower appellate court also misstate. If you have refused the money order, then the money order comes back to me. I accept the money on that order. Therefore, the signature of mine is present. The trial court says this is a forged document because how could the defendant signature is there? You should have put this question to my witness. How you?
Oh, the signature is your signature.
So because
So it automatically yes. If you refuse it, then the money has to come back.
Come back to me.
Someone has to receive.
No, signature of the payee means the person who is receiving the rent.
So you refuse.
It would be the lessor to whom the money is being sent.
That's it. The document.
Please understand. I think there is some confusion in understanding.
And this is since June 2012. From 2009 to 2012.
No, all these are not exhibit with objection, Mr. Counsel. Exhibit A series, exhibit all with objections.
It says that if it is marked with objection, then it is for the person who is relying on the document to produce the appropriate person from the postal office.
Who is the landlord? What is the name of the landlord?
Landlord is Rajan Prajari.
And remitter's address and mentioned, and then
Who marked these documents? Exhibit A1, A2, A3. Who has marked this?
and yes, the original defendants, they were not examined. And the person, the Bhatija, he says that I am not. I can also show.
Fundamental point which I need to raise over
Independent or not.
Yes.
I am, if eruption has the written box which I have submitted.
Okay, we'll hear this under order 41 with all the IAs. Interim audit is not up till a particular date.
So we are paying and continuous.
So this is not necessary. Okay, you write down without any. On the request, there's this case under the heading for order for hearing under order 41 rule 11 first up. The interim order to continue in usual course. This appeal is of the year
2019.
Let me take up some 15-16 matters. You go on paying the rent. Usual course.
Serial number 24, second appeal 63 of 90, Mr. Anup Kumar Mehta.
Why it is for order? Why should I condone the delay of 1554? That means how many years? How many years?
More than 4 years.
More than 4 years. Why? Let us see the IA application.
Yes. It's IA number 2429.
The judgment of reversal.
Yes.
What was the prayer in the suit?
The prayer in the suit was for a declaration that the superannuation is illegal and wrong.
So he is a workman.
He is a workman.
You should go and raise an ID.
He had gone there. He had lost there. Thereafter, after retiring to the year 2000, he files a title suit in the year 2002, and that has been.
You should notice on the limitation matter and the stay matter. Both process requisites 14 working days.
Serial number 25, second appeal 70 of 20, Mr. Yashwardhan, photo appellant.
Today has come for consideration on a state petition. Filed recently.
Stay.
Madam.
What is that intervenor petition?
Intervention petition in the second one.
What is the question of intervention? What is the scope of intervention? Who wants to intervene?
So property which had been.
It's a partition suit.
Yes, because I have not received a copy of this intervention.
You have filed intervention petition.
My magistrate on that day refused to receive the copy. Now it is intended to receive and serve the copy for you.
Order 41, Rule 5.
Well, this is my petition. IA number 1677 of 2000.
IA number?
1677 of 2022. This is a petition under order 41 rule 5.
Look at the IA number so and so. 1671.
1677 is my petition.
1677.
Under order 41.
Look at this petition has been filed under order 41, Rule 5, related section 151 of the CPC to stay the execution proceeding. To stay the execution proceeding 53 of 2019. Full stop. Next paragraph. From the order sheets, I find that the case has not yet been admitted, nor any point of law as yet has been framed. Full stop. Thus, this case under order for hearing under order 41, Rule 11 of the CPC on 24th.
In fact, when I had got refused, I said it is not admitted. How can I receive a petition for intervention?
You have no right.
Yes. There is one password matter in order.
Password.
Password matter. Serial number 70, second appeal Point 9 of 16, Mr. Pravat Kumar Sinha.
State my mistake of my club. I lost my return petition.
You want some time?
Next.
Mr. Pravat Sinha prays for some time. This case is adjourned to be listed after 1 week.
Under the heading for admission, serial number 26, MA number 503 of 16.
My lord, we have discussed this case to be referred to local arrest. On the last meeting, see our call for your claiming that interest has not been paid. And there is no bachelor part of the.
Let us see the LCR.
Yes. That will be such a
Where is LCR?
You have not seen the LCR from section. Can you pass over ID?
Bring it. Possible.
Serial number 27 with serial number 28. First appeal 257 of 90 with first appeal 289 of 70.
Second serial number 28 of 5 to 1 the matter is already settled by your office. The issue the present case is already settled by your office. There is a judgment passed by your office and there are other judgments also. There is nothing much to argue this matter.
No, there is one. Just a minute. Substitution petition which I see.
That substitution has been filed in my case since the original argument had died here. But the fact remains that this case would not be.
No, the jurisdiction is not here.
Yes, so there is nothing much to argue this case. To indicate the name of my senior.
This is out of a reference.
Yes, sir. Out of section 70.
Order dated 3/6/2020 in the second matter, you are started 289.
And no, what is the value?
In my case, the valuation is 11 lakhs and order.
And the other case?
Lordship, that they have come for enhancement, your lordship, because for the value is.
Yes, both the cases are on different protection. In my case, was given that.
So then how it got tagged?
I got about the question that whether the appeal will lie in this high court or whether it will have to go to the court.
So it is the full bench is there.
Yes, sir. That is why I said that nothing much to argue this matter.
That is why, your lordship, I was praying that your lordship sees order dated 3/6/2020 in second matter, your lordship, FA 289 of 2006.
289.
Yes, sir. It was back for this purpose.
So how could this case be admitted when the court didn't have a jurisdiction to admit this case?
The court has said that under reference under section 30 appeal under section 54 of the Land Acquisition Act would not be the 96.
That is the full bench.
Yes, Lord. And since the jurisdiction has changed pursuant to the amendment in the year 2019, now it has to be limited back to the court below.
In
Lordship का बहुत सारे judgment रहा है, Lordship का ये first appeal है Lordship. the court has posed a question whether it can appeal under section 54.
This question is already answered. Where is that judgment? Ghanshyam Tiwari?
Yes.
It's a full bench. Suraj Narayan Jadhav is the Patna one. It's 88, but Ghanshyam Tiwari is 2002.
Yes, both the judgments.
What show me Ghanshyam Tiwari?
And in fact, there was one more judgment from Honorable Mr. Justice Kamba in the first appeal on the basis of which this office not in my case.
No, that is for that is not on the issue of Land Acquisition Act Section 30. That is enhancement of the.
नहीं, इसमें भी वही था. इसमें भी हमारे पास आपके जजमेंट में वही था. वो दोनों जजमेंट में वही था. I have read it in detail. The court has come to a finding since the right title and interest of the person is being determined that who will receive the compensation amount. Therefore, it is not an award. It is a dignity.
Because the title is being decided.
Yes, Your Honor. इसलिए मैं बस कोई स्कोप नहीं बचा है बहस करने के लिए. There's no point keeping the appeal pending here.
Over here also the interest is involved.
The amount of compensation.
It is only the amount of compensation which is under dispute.
Yes. And the dispute is not with regard to the amount, Lord. The dispute is with regard to the entitlement that who will get that.
In this case, in
yes,
your case, in both the cases.
In my case, the first one, 257.
And who is? Let us take one.
Yes.
In your case, the entitlement.
Yes.
Who are you?
Lordship, I am PCC against the second case.
In his case.
Not in his case.
So who is?
Notices were never issued to us in this matter. Since the office has found out the defense that this appeal is not maintainable, notices were never issued. And after doing all the research work, I could also come to this point that this appeal would not be maintainable.
How this? No, in your case, there is an order dated 24th October 2019.
Yes.
Holding that this first appeal has been rightly filed before this court, in spite of pecuniary jurisdiction, considering 74 of the right to fair compensation and transparency in Land Acquisition Act.
That was my submission.
So you accepted that this is the.
That's the contract day, but after making the examiner and after making the necessary research work, I could find all those judgments also.
What is 74?
74 of the new act. The earlier act, the appeals were being filed.
This was under the new act.
This was filed in both the provisions of law.
So how can that be?
I have mentioned it in the first title, but this would have been under the report. Since the new act came into picture after 2013, I have mentioned 54, date is 74. Lordship permits I can read that section also.
Let's see section 74
yes.
of the new act. But your suit was under the old act.
Yes, sir.
The judgment came in 2019. What is the effective date of the old act, new act?
New act.
Let me see 74. Right to fair compensation and transparency in land acquisition, rehabilitation, resettlement act of 2013.
It has come into force on such date as the central government gave a notification to official gazette appointed.
It came into effect from which date?
Brought into force on 1/1/2014 by Testo 3729 dated 19/2014.
1/1/2014. 1/1/2014. What is 74? Let's see.
Yes. appealed to High Court.
Just a minute.
Perhaps page number 14.
Yes.
Appeals to High Court. The requiring body or any person aggrieved by the award caused by an authority under section 69 may file an appeal to the High Court within 60 days from the date of award, provided that the High
What is
Court
69?
69. Determination of award by authority. In determining the award, determining the amount of compensation to be awarded for land acquired, including the rehabilitation and resettlement entitlements. The authorities have taken into consideration whether the collector followed the parameters set out under section 26 to section 30 and the provisions under chapter 5 of this act. In addition to the market value of the land, the above provided, the authorities shall in every case award an amount calculated at the rate of 12% per annum on such market rates so. So the second portion would not be applicable in my case. The first is with regard to entitlement. And
So entitlement is also under section 69.
69.
So as per the new act, this court will have a jurisdiction. It says in determining the amount of compensation to be awarded for land acquired, including the rehabilitation and resettlement entitlements. Now, if you are saying that I am entitled, X is not entitled, that will also have to be determined under section 69.
69. And that is, Lakshmi kindly read side by side section 30 of the old act.
Now the question is, your case was under the old act.
Yes.
Your judgment was under the old act.
Yes. The reference was made under the old act.
Old act.
Yes. After making the reference, the act does not play any more role because only CPC would be applicable.
Yes.
Determining the title.
Now, then the old act was repealed.
Yes, the old act was repealed. The repeal and saving clause there is section 114, page number
114, let's see 114.
The Land Acquisition Act 1894 is hereby repealed, save as otherwise provided in this act. The repeal under subsection 1 shall not be held to prejudice or affect the general application of section 6 of the General Clauses Act with regard to the effect of repeals.
What does it mean? So, your appeal will be under section 74.
In fact, what had happened is all the previous judgments were they have ruled that even for the entitlement, the title has to be decided.
So, over here the entitlement is under section 69, and any order passed under section 69 is appealable before this court.
The same as in section 30 also.
Let's see the old act.
Yes, sir. Here also it was before High Court only. Section 30. Land Acquisition Act 89. Section 30.
Yes.
When the amount of compensation has been settled under section 11, if any dispute as to the apportionment of the same first part or any part thereof, or as to the person to whom the same or any part thereof is payable. Now this is with regard to entitlement. The collector may refer such dispute to the decision of the court. This, as per my understanding, the section 30 is parliamentary section 69 of the new act. In the new act, there is a specific terminology with entitlement. The word used here is as to the person to whom the same or any part thereof is payable. Now, section 30 का हम अभी जो section 54 में फाइल किया गया था मेरे द्वारा, उसमें स्पेसिफिकली बोला गया है कि हाई कोर्ट में ही आएगा. But even in spite that, all the courts will have held
कि नहीं वो 54 का अपील नहीं है, वो 96 का अपील होगा, सिंस दी entitlement, the title of that money is being decided, पैसा किसको जाएगा. Compensation is not being decided कि ना compensation कम है या ज़्यादा है. Section 54 reads, subject to the provision of the Code of Civil Procedure 1908, applicable to appeal from the original decree and notwithstanding anything to the contrary in any enactment for the time being in force, and appeal shall only lie in any proceeding under this Act to the High Court from the award. And इसी को द्वारा नाम डिटेल किया जाता है, ये प्रोविजन में डेवलप of the old Act. Para 9 में का finding दिए थे S3. It is therefore clear that an appeal against the judgment and award passed in the Land Act Acquisition Judge on reference under Section 30 of the Act is guided by the Code of Civil Procedure. In other words, Section 54.
Who is appearing in the other case?
Other case, the name of Tapan Kumar and Shubham.
Where are they? Is this case after Rowley as the counsel in case number 289 is absent. It will immediately come. It will come. Let's see. You keep the judgments with you. दे दीजिए हमको.
Passover medal, under the heading admission, serial number 26, MA number 503 of 16.
The right of recovery is there. Yes, the owner was there on the last occasion. Rajesh Mata was here. How many witnesses were examined on your behalf? 5. You took 1 year to examine 5 witnesses.
And one thing, your future prospect has been awarded in the system was PPA. There are levels of different from the hypothesis. Future prospect cannot be considered. That too at 50%. That is the order of the
So sending it to the Lok Adalat, they decide?
Yes, sir. Yes.
It has been submitted that the dispute can be resolved in Lok Adalat as all the parties have appeared in this case and there is a chance of settlement. Stop. Refer this matter to the Lok Adalat. So in 163A, where is the scope of future prospect? Now most probably the new Act, the 163A has been done away with.
Under the heading hearing under order 41/11 of CTC, serial number 29, second appeal 491 of 50, Mr. Mohammed Shamim Akhtar.
This is a case in which 4 group of land, there is dispute for only 4 groups of.
4 dhurs.
4 groups.
That means how many square feet?
Maybe 50 square feet of. 12 is equal to 1 decimal.
Oh, this is the brother and sister.
Brother and sister.
Contact me.
Yes. 4 dhur means how much? 4 dhur means how much?
12 is equal to 1 decimal. 12 is equal to 1 decimal.
12 dhur is 1 decimal.
1/4 decimal.
So this is 4 dhur. 4 dhur. That is 1/3. 1 decimal means how many square feet? How much? How much? Yes.
Square.
272 square feet. 1 decimal.
That is 4 dhur.
No, 1 decimal means how
4
much?
is equal to 4 into 68.05 is equal to 272 square.
Square feet.
Yes. 1 dhur is equal to 68.05 square.
Square meter.
Square feet.
1 decimal means how many square feet? 435 square feet is 1 decimal. That means 4 dhur will be much less than that.
Not a single room can be erected. Not a single room can be erected.
So 4 dhur means how many square feet I am asking you? 1 decimal means how many square feet?
Maybe 72 or 70 square feet.
720. Just give me the correct measurement. Yes? Anyone can help?
It is 435.6 square.
435.6
square.
Square feet is 1 decimal.
1 decimal.
So it's divided by 3. How much? It's some 100 point. How much? Check it out. 435.6 divided by 3. $145 square feet. Four dur is 145 square feet. Then, so if you are saying 4 dur is
1 decimal of that.
12 dur is 1 decimal of that. So here the dispute is, that means 1/3 of a decimal. So 1 decimal is 435. So it should be how much? 145 square feet. 145 square feet.
That approximately 145 square.
145 square feet. It's 272. 4 dur is 272 square feet in Bihar. Okay. Now what is your point? It's a partition suit.
It cannot be partition. At section 3 of the Partition Act.
Like Partition Act. This is a partition suit filed by
My sister. Sister was pregnant and I was dependent.
the land belonged to who?
Belonged to father. It was divided with the father. And she has taken money for his share also. She has relinquished in favor of me.
Where is that?
8,200.
Where is that?
Exhibit A, but the work was supposed to have not divided on it because it was not registered. But it was family arrangement. And my statement is that it was not registered document because it was a family arrangement.
Section which are you referring to? This is a dwelling house. What is the judgment? Let's see.
Section 2 of the Act says that when the property is not partitionable, it is ordered by the court.
Yes.
Section 2. Whenever any suit for partition village is executed prior to the posting of number of shareholders therein or of any other special circumstances, division of the party property cannot reasonably or conveniently be made, and that the sale of property and distribution of proceeds would be more beneficial for all the shareholders. The court may keep its inflict on the interest of any such shareholder interested undividedly or collectively to the extent of one moiety or upward, direct the sale of the property and distribute the proceeds. But I am ready, here I am ready to give money for a share. And we have looked at section 3 of the partition. In any case,
is this applicable in this case? Is this applicable in this case?
Section 2 or 3?
Section 2.
But because he is having only 4 groups, he is having share of only 4 groups of land. It was decided by the court's law.
It says that whenever in any suit for partition in which, if instituted prior to the commencement of this act, what do you mean by this? And then there is also on the request of the parties. There was no request also. So then
Section 3 that we already did. Actually, it is not possible to partition the property.
So how are you saying that this is maintained? Now the second question is, the appellate court has held that the possession of one is possession of others also. Possession of one particular is the which is to be possession of others. Now, because of the jointness, this is on the basis of the jointness, the presumption of jointness, whether it is applicable to the Hindu law, whether it is applicable to the Mohammedan law. I am asking a question.
As per Mohammedan law, she is only sure
The court hold that because of the jointness, because it's a partition suit, it will be presumed that the parties are joint. There is a presumption. So, possession of one is possession of others. So, is this presumption applicable in the Mohammedan law? Is that presumption of jointness there? Presumption of jointness in the Hindu law. Second half, there is a different bench to answer this question. Is there any presumption of jointness in the Mohammedan law? So this, see, the concept of what in a Hindu law, in the partition suit, you cannot take a plea that the property is in possession of X. That means it will be treated to be a property of X. The others don't have any possession, because this presumption of jointness, possession of one means possession of all. Now, this is a presumption which is attached with the Hindu law. Now, over here the parties are Mohammedan. So, if you want to give the presumption of jointness, cannot incorporate that theory of Hindu law here. You cannot transpose. Now, whether is there any presumption of jointness in the Mohammedan law? No, you just these are the questions which has to be answered. If there is no presumption of jointness, then can you say that presumption position of one means the position of all?
In physical world. I will answer this question.
This is, you find it out. This point may go in your favor. Now the request of the learned counsel appearing on behalf of the applicant, this case is adjourned for 3 weeks. It will come after, don't worry. These are the old matters. It will be at the top of the list. And you also try to contact with your client. It's only 200 square feet. I don't know what you will get. It's much smaller than this room also.
Yes.
Appeal number 30, second appeal 57 of 16, Mr. Sarju Prasad.
The appellants were 20. And what happened my lord, on 25th May 2015, they have executed 370 in favor of respondent number 1 and 2 in favor of respondent number 1 and 1 in favor
The suit
of
for
respondent number 2.
the suit for cancellation of the sale deed. Let us read the judgment of the title suit. Yes, from the judgment?
Yes.
Yes.
The instant could have been filed by the plaintiff was complete in favor of plaintiff declaring the sale is executed by the party in favor of defendants dated 25th May 2007, declaring incooperative illegal and the plaintiffs are not bound for the sale, and the sale may be cancelled and for the cost of the suit and other relief for gifts which the plaintiff had intended. Plaintiff's case in short, Gambas is this that the plaintiffs are by law covered by an obligation of Mohammedan law in matters of inheritance and succession, but defendants have
of the defendant located in Urdu, Block Ranchi, and the defendants are remitting the rent up to date and obtaining receipt thereof. It is further the case of the plaintiff that after execution of the sale deed, the mutation of the name of the defendants, the plaintiff approached several times to the defendants for being rest of the amount in this regard. An instrument has been executed between the parties on 25th May 2007 called the Prapti Receipt. The defendants neither paid the rest amount nor any satisfactory explanation was made. Lastly, plaintiff sent legal notice on 22/8/2007 and 23rd January 2008, but no reply has been settled from the side of defendant. The plaintiff orally requested the defendant to instigate a real controversy, but the defendant gave up. The cause of action arose on 22nd August 2007 and 23rd January 2003 and other subsequent dates for institution of the claims. The suit value at rupees 2,50,000 for the purpose of court fee and the jurisdiction of the court. The plaintiff paid at Waltham Court. Defendants appeared and filed written statement. It has been stated that the defendant that the suit is false, frivolous, and reckless and liable to be used. The suit is not maintainable and barred by principle of waiver, stoppage, ignorance, and hit by the provisions of the code of the specific fact. The suit has been grossly undervalued. There is no cause of action for the suit. The suit is bad for misjoinder of parties. The plaintiff is in need of money. Approach the defendants to purchase the suit property. The defendants have not executed safely to anybody. The defendants further stated that in their statement, the plaintiff executed the sale deed. 2 sale deeds have been executed in favor of defendant 1 and 1 sale deed in favor of defendant 2 on 25th May 2007 after receipt of the entire consideration money, which are evident from the recital of these deeds executed by the plaintiff, and in this way the right evidence possession of the land and the deeds were transferred to the defendant and further authorized the defendant to get their name mutated in the state of Jharkhand and use the land under deeds as their own choice. On the basis of the bidding of both the parties, following issues are: number 1, is the suit maintainable and court. Number 2, have the plaintiff got to pay cause of action for the present suit. Number 3, is the suit barred by law of limitation and adverse possession. Number 4, is the suit barred under section 34 of the Special Act. Number 5, whether the plaintiff received the entire consideration money of the sale deed and defendants, whether the plaintiff is willing and ready to purchase the suit land, whether the defendants acquired right title interest over the suit property of their sale deed without payment of entire consideration money, what relief and reliefs the plaintiff is entitled. The plaintiffs have adduced 6 witnesses. They are Shankar Lohra, PW1, Samsuddin Ansari, PW2, Raji Ahmad, PW3, Muhammad Harun, PW4, Muhammad Ilyas, PW5, and Muhammad Irfan, PW6. Besides, 8 the plaintiffs have executed following. Exhibit 1 is money receipt dated 25th May 2007. Exhibit 2, legal notice dated 22nd August 2007. Exhibit 3 is registered in Vela. Exhibit 4, sale deed dated 28/8/2075. Exhibit 5, government rent receipt. Exhibit 5A, government rent receipt number so and so. Defendant has adduced 5 witnesses. They are Jitendra Prasad, PW1, Ajit Sahu, DW2, Ashok Prasad, DW3, and Sudhik Sahu, DW4. Mithilesh Prasad, DW4. Besides, the defendants have agreed following. Agreed A to A by Roman 2, 3 certified copy of CLD dated 25th May 2007. Agreed B, political agreement dated 11/5/2007. Agreed C and C2, 3 corrections here. Agreed E to E by Roman 2, 3 government country. Agreed E to E1, 2 bank statement. Issue number 7. This issue is an important issue and therefore issue is taken up for consideration first. The plaintiff in this student has stated that on the basis of agreement, 3 salaries were executed in favor of defendant on 25th May 2007 in respect of data number 280.
So, your case is that the entire consideration money was not paid, so the sale deed has to be declared landlord. What is the latest judgment 2 months or 1 month back on this issue? Number 1. Number 2, both the courts have held that the money has been paid. So, is it not an absolute question of fact? Whether the entire consideration money has been paid or not. This is the issue? Is it not a question of fact?
Question of fact, certainly. But they have not considered the agreed one matter, which says that their consideration money will be paid after notation of the land acquisition.
No, but it has been considered. Exhibit 1 is the money receipt.
Money receipt.
It has been considered, but read with the sale deeds, the court has come to a conclusion that the money was paid.
Yes.
Then just a 1 month or 2 months back, exactly on the similar issue. Wait. I have sent it to my legal research assistant. Part of the money was paid.
Yes.
The entire was not paid. This is your case.
The receipt agreed one says that a sum of rupees 2,50,000 will have to be paid after the mutation of the land. So this was an admission matter. There is admission in selling as a recycle and there is admission in this money receipt also.
So the trial court says that you can file a money suit.
Money suit, yes. There is the finding. You can claim for money.
This is not a ground to declare the sale deed null and void.
That is the finding of the court.
What is the date of that annexure 1?
Annexure 1 same day, 28 May 2007. May I read that?
You have with you?
Yes, I have.
And sale deed is also dated 25/7/2007.
Yes, same day.
Yes.
प्राप्ति रसीद प्रथम पक्ष मोहम्मद इलियास वो मोहम्मद इरफान वो मोहम्मद हारून पिता लड़के मोहम्मद सुलेमान जाति मुसलमान सभी का पेशा खेतीबाड़ी निवास ग्राम सोयनसो थाना सोयनसो दीवारांची विक्रेता द्वितीय पक्ष मिथिलेश प्रसाद वंश श्री वासुदेव साहू जाति स्वामी पेशा निवास स्थान जिला रांची क्रेता संदर्भ एक पिता जमीन 1 एकड़ 15 डेसिमल का रजिस्ट्री आज दिनांक 25 मई 2007 को द्वितीय पक्ष के नाम से कर दिया। इसमें जमीन का पूर्ण राशि प्रथम पक्ष को नहीं दिया गया है, जबकि बकाया पैसा 2,50,000 प्रथम पक्ष को उपरोक्त भूमि को दाखिल खारिज के बाद दिया जाएगा। यह इकरारनामा लिख दिया ताकि वक्त पर काम आगे प्रमाण रहे। विवाह का हस्ताक्षर और दोनों पार्टी का
What is the agreement dated 11/5/2007?
11/5/2007। इसमें 2 एकड़ 40 डिसमिल का बेचने की बात है, तो इसमें से कुछ 2 एकड़ 43 और उस समय जो है सो 1,25,000 जो है सो एडवांस किया गया था। और उसी दिन हमारे ये भी है कि 7 अदर सेल भी इन्हीं के डिस्काउंट पर हमने शुरू किया है, और वो जो पैसा है वो सब पैसा में जो 7 अदर सेल है उसमें एडजस्ट हुआ है।
What was the total consideration amount agreed by the party? 2,50,000. 2,50,000.
Yes.
It is the total consideration amount. And your witnesses said that 1,50,000 has already been paid.
That has been paid, my lord, but there are altogether 10 sale deeds.
So you say this 1,50,000 is respect of other sale deeds?
Yes.
Not these 3 sale deeds?
Not.
Now this agreement is in respect of which sale deed?
This is
Annexure Exhibit 1?
May I, Exhibit 1 is with respect to this particular sale deed in the name of Mithilesh Kumar and his wife.
So, no, in the name of Mithilesh Kumar and his wife, how many sale deeds are there? Only 3. So then, how you say that 1,50,000 relates to the other sale deed when your witness is saying that they have paid 1,50,000?
At
So, by Mithilesh Kumar. So then how can you say that the entire money is due?
Had not been the fact, my lord, then the Mithilesh Kumar should not have executed this property receipt, in which he has admitted that 2,50,000 is due.
Then what prevented you from writing in the deed that the payment will be paid on a such and such date?
My lord, they are asking people, and what this guy write. And there was some understanding between.
Recent judgment. Huh? See, the Honorable Supreme Court says the price can be paid at a future date also.
Yes.
So it says that if there is nothing to show that the price will be paid in the future, then the sale deed is void. If there is something to show that the price can be paid at a future date, then it cannot be void. It says if there is nothing to show that, see, hence a sale of an immovable property has to be for a price. The price may be payable in future, in your case. It may be partly paid and remaining part can be made payable in future. The payment of a price is an essential part of sale covered by Section 54 of the Transfer of Property Act. If a sale deed in respect of an immovable property is executed without payment of price and it does not provide for payment of price at a future date, it is not a sale in the eye of law. In your case, the sale deed provides that the money has been paid.
In the sale deed, they but the property receipt.
So the property receipt that has been, the court has disbelieved. court says that no, it has been paid, you have failed to prove, and it's a question of fact. Take note. Heard the counsel appearing on behalf of the appellants. As this case has been heard under Order 41 to Rule 11 of the CPC. Next, a very short point is involved in this case as to whether the consideration money in lieu of sale of land has been paid to the plaintiff, oblique seller or not. The title suit, this is second appeal under section 100 of the CPC by the plaintiff appellant appellants. The title suit was filed by the appellants herein, being the plaintiff, being title suit number 301 of 2008, praying therein for a declaration that the sale deed executed by the plaintiff in favor of the defendants dated 25/5/2007 is illegal, void, inoperative, and are not binding, and should be cancelled. First time. This prayer was made on the background, on the claim that though the sale deeds were executed, possession was given, and the land was duly mutated in the name of the purchaser, yet the consideration money was not paid. First off. The trial court, after framing the issues and considering the evidence of the parties, have held that the consideration money has passed, thus dismiss the suit. First up. Challenging this said finding, the plaintiff, oblique appellant, filed civil appeal number 33 of 2013 under section 96 of the CPC before the first appellate court. First up. The first appellate court independently considered the evidence and came and reached at an independent finding that the consideration money was paid, and thus this suit was correctly dismissed. So next paragraph. The learned counsel for the appellant submits that Exhibit 1 series, Exhibit 1 was not considered by both the courts in a proper manner. He submits that there is an admission in the Exhibit 1 that part of the consideration money will be paid after the land is mutated in the name of the purchaser. He submits that the land was duly mutated in the name of the purchaser, but since the amount has not been paid in terms of the promise, the sale deed needs to be cancelled and set aside. He submits that this position has not been well appreciated by the by the trial court nor the first appellate court. Thus, he submits that this appeal should be heard on a question of law which is formulated and mentioned in the memo of appeal. After hearing the counsel for the appellant, I have gone through both the judgments. The issue which has been raised in this appeal is as to whether the consideration money has been paid to the seller by the buyer or not. First, this fact has been considered, and both the courts considered these sale deeds, which is Exhibit A series, and came to a conclusion that after receiving the money from the purchaser, the sale deed was executed. First, the first appellate court also considered the evidence of the witnesses of the plaintiff, oblique appellant herein, wherein PW number 1, 2 and 3 has categorically stated that in advance 1,50,000 rupees was paid. First up, the first appellate court thus held that the the evidence of the plaintiff is inconsistent, and rather there are evidence to show that the consideration money was paid. Full stop. Thus, both the courts arrived at a concurrent finding that the consideration amount was paid by the purchaser, that is the defendant respondent herein, by to the plaintiff appellants. Full stop. Next. Whether the consideration money has been paid or not is an absolute question of fact. Full stop. Both the courts concurrently arrived at the fact that the consideration money was paid. Full stop. This court, while exercising jurisdiction under section 100 of the CPC, cannot reappreciate the facts which has been arrived at concurrently by both the courts. Full stop. Since both the courts have given a concurrent, has arrived at a concurrent finding of fact that the consideration money has been transferred, so I find no substantial question of law involved in this appeal. This appeal is thus dismissed.